Good morning, good afternoon, good evening, whatever time of the day it is where you are. Welcome to our webinar today. If you've joined us before, you know that I like to just dive right in with a little introduction of the ICCP before I hand it over. So, So who is the ICCP? Who are we? What do we do? Well, very simply, we are a professional members organization that recognizes those with the skills, qualifications, and expertise in the professional management of construction claims. And we have three primary objectives, and those are to establish international professional standards for the management of claims, to give recognition to those who have gained that appropriate knowledge and experience, and also to help educate those who wish to gain that experience. And why is there a need for the ICCP when there are so many professional organizations in the construction industry? Well, quite simply, construction claims have become a key part of the international construction industry, and people come into the claims arena from a broad variety of backgrounds within construction, including engineering, quantity surveying, project management, and law, et cetera, et cetera. And until the ICCP, there has been no institute that specifically recognizes those who have that specialist knowledge, experience, and skills to appropriately manage, prepare, and respond to claims. Okay, so I would like to point out that we have a steering committee composed of our executive officer, an elected president, and 3 elected fellows, in addition to our general manager, Nina, who is currently on maternity leave. So I am filling in for her for the time being. Okay, in terms of membership, we have 3 levels of individual membership. Each have their own criteria for achieving. We also have student and graduate memberships for those working toward an initial undergraduate qualification. We also have corporate membership for companies either that specialize completely in claims or have dedicated claims departments. And what's in it for you? What do members get out of their membership? Well, we have a private members area, which has a knowledge library, which is a collection of research, white papers, articles, etc. We have a bank of practical templates that help our members save time and also ensure that their claims are done to the highest standard. We have regular CPD opportunities like this. So most of our CPD webinars are open to the public, but only members will receive a CPD certificate. We also have the ICCP Academy, which are more technical webinars, which are for members only. We additionally have discounts on books through Wiley Blackwell and Routledge, as well as through our training partner Claims Class. Our members receive a monthly newsletter, which keeps them up to date on the latest happenings in the industry. We offer industry exposure in the form of a public listing of our members, as well as the usual benefits of a logo and membership certificate. We also have a private LinkedIn group where our members can discuss their contracts and claims questions in a confidential setting. And we have the optional benefit of the Register of Claims Practitioners, which is a popular option with our consultant members. I know that was a very quick little spin around the ICCP. If you requested additional information when you registered for this webinar, you will be receiving an email from me. And if you did not request additional information, but you would like some, you may contact me at jennifer.smith@instituteccp.com or visit our website. And I would also just like to announce that in September, we will be having our first conference. This will be a half-day online conference, Construction Claims and Dispute Avoidance, how to achieve successful outcomes. And registration has opened for that. That will be free for members, And until July 14th, non-members can register at the early bird rate of £40. And after the 14th of July, registration will be £50, which I think is quite reasonable for a half-day conference. I am just about ready to turn it over. First, I would like to introduce Uditha. He is a claims consultant, expert witness, and a practitioner in the field of arbitration, as well as a fellow of the Chartered Institute of Arbitrators and a member of both RICS and Australian Institute of Quantity Surveyors. He possesses years of managerial, engineering, and technical experience in various building and civil engineering projects in the Middle East, South Asia, and the United Kingdom geographically, with a wide exposure to different types of claims and numerous commercial and contractual matters, starting from inception to final accounts of projects. He is presently working as a claims specialist in the preparation, defending, and evaluation of construction claims, while representing a major multinational real estate organization as a head of the contracts and claims department, and a senior representative for dispute resolution forums, amicable negotiations for disputes between contractor, employer, and subcontractors, and technical counsel in litigation and arbitration. So I think we can all agree that he is very well suited to imparting some wisdom on today's topic. So with that, I will hand it over. Thank you, Uditha.
Well, again, thanks for the opportunity. Well, I really appreciate this opportunity to share something with a common interest group, which is about construction claims. You can rarely find such groups, especially like particularly related to construction claims. Which is, of course, a complex area, but quite interesting. My experience is largely related to claims preparation and evaluation, defense, expert witnessing, and arbitration. So I'm going to share with you my experience as we go ahead through the presentation. Well, speaking about myself, in addition to the given introduction, so here's my brief experience and how I qualify to talk about this, and brief notes as to how I'm qualified to talk about the topic. Well, I'm presently working as a claims specialist and involved in preparation and defending and evaluation of construction claims. I'm also an expert witness and mostly on the quantum, and have done forensic quantum analysis. And I've been appointed as an expert witness in some major construction arbitrations. And I've also been appointed as a counsel as well as a technical counsel in arbitration. Well, and also I've extensively involved in negotiating construction contracts and construction dispute for contractors, subcontractors, and owners. So my geographical experience are majorly related to Middle East, South Asia, and United Kingdom, and academically and USA at federal level. So with that, we are moving to like key points of the presentation, and there's speaking of which, there are certain points that should be noted before we proceed further. Now, I understand that the audience is from a number of different countries. So I started with, so because of that reason, I'm going to start with the common law approach. And there is very good reason why I should do so, because if you see, the participants, obviously they are familiar with different forms of contracts. So they address the things in a different way. But if you look at them, if you look at all of them, most of them, and they are in line with the common law proposition and common law approach of like entitlement and valuation, at least in related to construction termination claims. And with that, then we are moving into discuss different forms of contract. And but I'm going to discuss the topic as much as possible uh, related to different jurisdictions and different related to different forms of contracts. And for that reason, I have extracted some clauses from FIDIC, JCT, as well as AIA, American Institute of Architects. So, but while doing so, I'm going to step into the shoes of claims consultant and the forensic quantum expert time to time to explain the difference and they explain how one should, the major points one should taken into consideration in performing these different roles. Well, I presume the audience know the difference well of the quantum expert and the claims consultant. Just to give you a brief, the expert witness is an independent party, or like he's an expert who's testifying in an independent capacity, while based on the facts and not the liability or legal issues. And well, consultant usually represent the best interest of the party who they work for, and may dig into all forms of entitlement and factual, legal entitlement, contractual entitlement, and they do as much as possible to, to achieve the interest of the party they're representing. So, well, then there'll be, of course, tips for the counsels, attorneys, and contract administrators while performing with these different procedure of termination. And there'll be tips, there'll be arguments for attorneys, those who represent parties in a dispute, like and also in arbitration. So we'll see how we accommodate all these points and perspectives within the given time. Although there is an outline, this is our presentation outline today. Like we're going to be discussing key aspects, basic terminology of termination, and then we are moving to discuss the termination under common law, and then termination under the contract, and then the heads of damages. The different, as I said, different heads of claims and damages for the owners and the contractors, and then finally we're moving to onto settlement procedure. And this is the brief outline, but there is no guarantee that I'm going to stick into these topics, and we are going to discuss much more things, and hence, like you will gain much more knowledge than what is in there, the basic outline of the presentation. However, this is just a formality of having brief topics. And with that, like we will move to the key aspects and the basic part of the termination. Now, in general, parties to the contract, they cannot terminate the contract before it has been fully performed, unless, of course, there is an express power to do so. So what they need to terminate the contract is like either they need to perform the contract, either they should have a lawful reason or the other party's consent. So this is how it should be, and there are no other options. But provided that how it is addressed, like how you initiate the termination, like we have different type of we have different circumstances of termination. First one is at common law, where the contract has been repudiated. So there has been an anticipatory breach, or I'm going to explain these terms like in the coming slides. Or there is a breach of the serious term, and this is one of the circumstances of termination. Or it can be under the contract itself. Well, where the contract give express right to the other party to terminate. And I'll show you many examples of this from FIDICs and JCT contracts. And the other circumstances are the contract is terminated prospectively or retrospectively uh, due to frustration, illegality, or like impossibility or death of a party, something like that. And and there is an express right from the statute to terminate the contract, or like by performing all the obligations. So these are the circumstances of termination. And I'm going to show you, this is a good example of right to terminate under the statute, and this is extracted from Building Works Contractors Act 1995, South Australia, version 4th May 2020. And if you read the clause, it says like the building owner under the domestic building work contract may by instrument in writing signed by the building owner and served personally on the building works contractor or posted by certified mail addressed to the contractor before the prescribed time, give notice to the contractor of the building owner's intention not to be bound by the contract, and the contractee is to be taken to have been terminated at the time the notice is served or posted in accordance with this subsection. So this is an example of right to terminate under the statute, in case if you wonder how it is given. And with that, we are moving to the key aspects of termination. So earlier we discussed what are the circumstances of termination, and now we are going to discuss what are the key aspects of termination. Well, I was often told that like termination claims are like even in the arbitration as an expert witness or a claims consultant, and whatever the role you are performing, like I was told that the termination claims are very difficult. In fact, when you are an expert witness, it is even more difficult, as she or he has to be independent and should exercise all caution not to touch, like not to be partial or not to touch any issues of liability or legal aspects. So it's even more difficult. And why is it so difficult? Because well, firstly, and most commonly, and you get all types of claims inside a termination claim. Well, I mean, recently I'm involved in arbitration as an expert witness of which involved in a termination claim, where about 30% is of the full claim is related to prolongation cost, and another roughly approximately 20 to 30% is related to unpaid work performed, and another 5% is about increased overheads, and and then you have an acceleration damages. And this is one of the reason why it is difficult. So you have to be familiar with all sort of claims in order to complete the exercise. And the major reason is that that's not the major reason although, but the major reason, well, it has to be distinguished in many respects. Well, for instance, there are four basic distinctions that has to be made, like that has to be considered, especially if you are representing if you are working as a claims consultant or you are representing a claimant. See, what are those four basic distinctions? Is the cause and the source of rights, and the party who initiated the termination, and the relief which the one party is seeking. Well, these distinctions are very useful in understanding and completing and compiling your termination claim. But the first distinction talk about the cause of the termination. The cause can be default, or it can be convenience, or it can be automatic termination. And the second distinction talk about the source, where the rights and obligation related to termination are defined. So it can be defined in the contract, or it can be defined in the statute, as I showed you a while ago. Or it can be from it can be from common law, by the common law. So there has to be a place where these rights and obligation and the procedure are defined. And the other question is who initiated the termination, whether it is a contractor, owner, or subcontractor, who initiated the termination. And the relief, sort of relief is innocent party is looking for. It can be damages at law, or it can be equitable relief, or like pre-agreed damages, like liquidated damages, or you can liquidate the. I mean, you can mention some pre-agreed amount, and then well, it can be losses and expenses under the contract, like in most common forms of contract. And why these aspects are important? Because the final amount of your termination claims, it depends on all of these questions. So all of these four aspects, actually. So that's why it is difficult. So you need to understand the cause of termination and where the rights are defined and who initiated the termination and what kind of relief you're looking for, whether you're resorting to relief under common law, whether you're resorting to the contract as a common law, or you might not have an option rather than making your claim under the contract. Sometimes the way the contracts are written, like the valuation clause itself is not valid when the termination is in place. So we have to ask number of different questions related to these four aspects before your pricing. Well, this could be the reason why it is said mostly the termination claims are difficult. Apart from the reason I just talked about, like the claims inside the claim. Well, with that, we'll be quickly moving to discuss the termination under the common law, which is the major reason being the breach of contract. Well, party to a contract, like usually they are entitled to terminate the contract or terminate or determine the contract, let's say, on more than one basis. For example, like the conduct, which is like a repudiatory or a serious breach at common law, may also constitute a breach under the contract itself. So now, well, as I said, like when I discuss proving and pricing termination claims, I cannot really discuss about all the forms of contract at once, especially at least within the given time. But the best thing is, like, as I said, all of them are in line with the principles of the common law. So let's start with common law and let's see how it is in line with the many forms of contract. So one of the major causes under the common law for termination is repudiation. So what is repudiation? Like, repudiation is the parties to contract. Like, repudiation has few aspects. Let's suppose if the contractor is causing a repudiation, like he manifests an intention no longer to be bound by the terms of the very contract he signed with the employer, or he shows an intention to perform in such a way which is drastically or substantially inconsistent with his obligation under the contract, or that could be due to his incapacity or his disability to perform his contractual obligation. But whatever happens, one thing is clear, because it's just not based on the opinion of the other party. Let's say you can't really say, oh, the contractor, in my opinion, you're in breach of contract, or my opinion, you're showing your intention not to perform the contract. You're performing in a totally different manner, substantially different manner, in an inconsistent manner. But that's not going to work, I'm afraid. So what is really required is an objective conduct. See, the objective conduct is that no matter who's judging, who's deciding whether there is repudiation or not, and the person may come up with the same answer. It's not subjective. It's not based on the discretion or opinion of either of the party. So it's a serious matter, which should not be found or inferred very lightly. So because sometimes, as it happens usually, the subcontractor, for example, may show his lack of willingness to perform, or some substandard quality of submittals and behind the schedule, and you may send thousands of letters, but when you show him his obligation and when you give him an authoritative exposition as to what he's obliged to do under his subcontract, but then he may start to go, okay, I will give you a mitigation plan and I'll give you a strategy to come up with recovery. I mean that's not going to be a repudiation then. So it's again a serious matter. It has to have a gravity of gravity of adverse, or the negativity of inconsistency, or yeah. And then the anticipatory breach is not an actual breach. It's a repudiation of a contractual obligation, which occurs usually before the performance has fallen due. So it's not an actual breach of contract, but it is also a species of a breach of contract. So, and because it involves a conduct which is contrary to what has been agreed under the contract, it will still be considered as a breach of contract and has the same consequence as a breach of contract. Yeah, but a good example is if I can give you an example, is let's say usually now to perform the work for the contractors to start executing their works, the owner needs to give the design drawings, authority approved drawings, or building permits and planning approvals, at least under traditional forms of contract, forms of procurement. And let's say before the owner supply all this stuff, now the contractor has ability to do some permanent temporary construction, but he shows his willingness not to construct the building, or not to start the work at all. So this might constitute again subjected to circumstances of the case, the facts of the case. This could subject it to repudiation, though the anticipatory breach, sorry. So then the breach of serious term is as you may have come across many times, is an essential term that usually goes to the heart of the contract, and which has a serious consequences, and the breaching of those will have an equal effect to the repudiation of the contract. So, sometimes the breach of contract, a single breach of contract, may not itself be important enough sometimes, but if the innocent party want to justify this termination, he can use the cumulative effect of number of breaches, and then he can find a basis for termination. An example for the repudiation or serious breach by the owner is to terminate the contract when when the employer doesn't have the express power under the contract and request to stop the work permanently to the contractor, or he might omit a sizable portion of the work, or non-payment. Just to keep in mind that a simple single non-payment may not constitute a repudiatory conduct, but sometimes it may. Or removal of the engineer or contract administrator. This could constitute sorry, a repudiatory breach from the owner's end. But speaking of serious breach by the contractor's end, where the contractor walk away from the site, or like he becomes insolvent, or like well, he shows his intention, as I said earlier, not to perform the work. Uh, these are the examples. Sometimes we often come across with issues where the contractor show his willingness, his non-willingness to perform the work further until he received the further payments, regardless of the fact whether he's really entitled for these payments under the contract or not. So these are the occasions where the contractor can cause a serious breach under a serious breach of contract. So with that, we are discussing the effect of termination under common law. And the effect is that you have to keep in mind that it's not to terminate the contract from the beginning. We call it ab initio. The parties' executory rights are still valid and intact, and like but the secondary obligations like they come into existence, but the executory rights come to an end, but the secondary rights are still valid. For example, right to payment after the termination, and sometimes the dispute resolution clause, yes, is still valid. So whatever the clauses that the parties choose to keep surviving after termination, and they are still valid. Sometimes it can be by implication, not necessary by express wording. So parties are relieved from further performance, which means that if the contractor is terminated by the employer, or like at least wrongfully ordered to leave the site, and he doesn't require to perform any further work at all. But however, if there is payment right acquired under the contract unconditionally before the termination, the contractor is still entitled for these payment which he has not earned the benefit of. This payment up to the point, the payment obligation up to the point of termination are still enforceable. So this is the effect of termination, and if the contractor is terminated by for the contractor's default, well, owner will have certain remedies. The owner will be entitled to recover damages for his losses from the termination, and usually this is the difference between the cost of completing the outstanding work and minus the amount of contract price which remain unpaid. But you have to keep in mind, when the owner is under duty to mitigate his losses, he can just like appoint a contractor to carry out the balance work, thinking that, oh, I'm getting paid for this, but I can deduct this from the contractor, so I'm going to go for the highest bidder. It doesn't matter. So no, this is not a mitigation of loss. And now what remedies are now available for the contractor? The contractor who accept if they accept the repudiation of the owner, and he's entitled to recover his losses and damages which is following from the termination of the contract. So his usually his expenditure, the amount he expended in performing the contract, but in respect of which he didn't earn the entitlement to the payment. And he may also recover the expectation damages, loss of profit on the remaining work, like usually the difference between the amount it would have been paid and the remainder of the work performed, and the amount it would have spent on completing that work. Well, any loss of profit claim, however, may be reduced to the extent that the other party shows the contractor They could have diverted his resources elsewhere and get the revenue. But overall, it's a different exercise, and it involves numerous like hypothetical matters, and even in speculations. And sometimes, if you're an expert witness, of course, this could be thoroughly cross-examined. This is an aspect which is, except for the apart from the overheads claims, which is thoroughly cross-examined. But if you're a claim consultant, you can, it's not that difficult. So, but the proving of the profits that's a critical matter. I'll explain to you in the forthcoming slides. And then now the alternative to these complex damage calculations, which I explained, are the quantum merit, which is not so easy as it sounds, but it's also contentious and subjective, and mostly subjected to recalculation by courts, tribunals. The basic principle is contractor should be able to recover a reasonable remuneration. That is what we call quantum merit. The work performed up to the point of termination. These are not made under the contract. So because of that, like the usual defenses of limitations, like the contractor's ability to recover, his ability to recover like in excess of contract price, are not applied. And the other important thing is, like, usually if the contract is completed, if it is contract has performed the work substantially, again it like his remedy will be under the contract, not under the quantum merit. But one hurdle when you're using a quantum merit claim is basically the loss of profit of the remainder works, and you will have a hard time recovering these loss of profits, because the quantum merit is an alternative to the actual damage claims. Let's move on to the termination pursuant to a contractual power, which is the one we are encountering most frequently. We also call it a code of termination, as the procedure is clearly set forth for termination for respective obligations. In this case, why we call it a code of termination is that contract itself act as a code to define and set forth the procedure and the rights and obligation of the parties. So which is very easy. Of course, you don't have to resort to all these common law claims or quantum merit claims and all this difficult, complex, and arguable stuff. The consequences of termination are also stated in the contract, usually prescribed in the contract. But the thing is, like, you have to use a well-recognized standard form of contract. And if you're trying to, have these termination clauses in the bespoke forms of contract, you sometimes might find it is very loosely or poorly drafted in such a way that even the drafting party want to recover some expenses and damages. It will make things very difficult for them. So as I said, like, the contract in this case, the act as an like a code, and the contract termination pursuant to contractual power. In this case, the contract may have expressly agreed consequences with regard to continuation of the parties' contractual rights. Which means, as I explained earlier, it is sometimes inaccurate to say the contract has been terminated or the contract as terminated in common law sense of termination. Well, what we can say is that the contract has been determined instead. Now, I've been asked the difference like a few times. So the the contract has been determined means the contract continue to operate and regulate the right and obligation of the parties throughout, although the contractor is, not required to perform any further work. But this is what we call the determination, not the engineer's determination under FIDIC, but this is something different. So, but this difference of termination and determination and the termination of the employment of the contractor, you can see this difference in FIDIC contracts, where under fourth editions of FIDIC, the wording they put it is the like termination of the employment of the contractor, and it is like the employment of the contractor that is terminated. However, under FIDIC 99 version, and they refer to it as a termination of the contract. Well, but one can argue this in either way, but like given the similarities between the consequences of the termination under common law and termination under the contract, and given that all the subsequent procedure are well defined in the contract itself, what happened after termination, how the contractor should be paid, how the owner should be paid. And as long as this is well addressed, and it matters little whether the contract, the termination is described as a termination or a determination. Is the procedure and the intention is that it's what matters. So again, it does matter, but if you're using a bespoke form of contract, this could still be an issue. Well, the common form in all forms of contract, the common aspect of all forms of contract is that if the contract is terminated, or let's say it's determined for contractor's default, the owner have the right to stop and cease further payment to the contractor, and they don't require to pay any further payment, and then the contract go ahead and explain the measure of recovery. So the owner is not required to make any further payment, and he may complete the work himself or engage someone else to do so. And once the work have been fully completed and maintained and final accounting has been completed, or then there is a final reckoning, and then if there is a balance, the contractor should be paid. Well, this is very common in most form of contract, and I'll show you like a few clauses in a while. But there are something which you need to keep in mind. But if the contractor is failing to complete the work, it's like as a natural consequences, the owner definitely required to employ someone else and to complete the work. And the measure of recovery is, in that case, usually the employer may complete the whole of the work and the total cost of the remaining work, and he will calculate total cost of the remaining works, and then he will calculate the amount that would have been paid to the original contractor, the previous contractor, completing that work under the contract. So this difference will then be recovered from the contractor. But somehow the ability to recover damages will be limited, like to the extent that the owner is acting reasonably, which I explained earlier. So he has to be duty to mitigate the losses. But there can be situations where the contractor is at the point of termination has has overshot the date of completion at the work. Now the owner, after terminating, after termination of the contract, trying to recover the liquidated damages up to the point of termination. Well, there is no hard and fast rule, of course, to this one, but it depends on the wording of the contract and how the contract has been drafted. And then there is a right, of course, to use the contractor's plant, equipment, and machinery. And this is common in construction contract to confer such right to the owner. And following the termination of the contractor's employment. And then with regards to the completion of the work, usually there is no rule that the employer should complete the works or like he should complete the work in the very way that it's included in the original contract. I mean, there is no hard and fast rule. He can perform the work. He can like introduce variation changes, but as long as there is sufficient correlation to the original work, I mean, there is no impediment to recover the damages by the owner. So these aspects are also defined in the termination clause for the owner's default. So this is one example. Now, like this one is taken from FIDIC 1999 first edition Red Book, which is a form of contract that is used for traditional remeasure type contract. Well, it says after notice of termination served, the employer may proceed in accordance with clause 2.5, the employer's claim. And this is an opportunity for employer to submit his old offsets and the contra charges against the contractor and delay damages up to the point of termination and withhold further payment until the replacement contractor has completed the work. And finally, he will calculate all these costs, and finally he will recover any losses and damages incurred by the employer and any extra cost of completing the works. Now, this is one example from FIDIC 1999, and let's look at a wording from the FIDIC 1997 fourth edition. It says cost of execution contract, like he shall not be liable to pay the contractor until the cost of execution, completion, and remedying of any defects, damages, and delay completion, and all the expenses incurred by the employer have been ascertained and the amount thereof certified by the engineer. And the contractor shall then be entitled to receive only such sums as the engineer may certify would have been payable to him upon due completion by him after deducting the said amount. Mostly same to what we have discussed earlier, but this is a sort of comparative analysis between the price of the old contractor and the prices of the replacement contractor, which means you like price all the changes, variation, extra works, delay damages, and all these day works from the old contractor's accounts and previous contractor's accounts for the balance work, and then you come up with the excess recovery and deduct that amount from the contractor. The approach is quite different, but it still covers the principle that the employee is recovering his expectation interest, the damages on the expectation interest, which means what he would have earned had the contractor has performed the contract as agreed. So, well, this one is extracted from JCT, clause 8.4 of JCT standard billing contract with quantities. Well, you can say it is quite similar to one of the FIDIC clauses of the FIDIC clauses we discussed. Yeah, with that, there are a few things that you need to keep in mind. These clauses made it clear that you need to carry out some valuations, and these valuations are valuation till the date of termination. And when you carry out this valuation, you need to check the reasonableness. As an expert witness, you need to see how it has been carried out, if the parties has agreed to it, or is it by the engineer under the contract where the engineer has the right to do so. But these aspects are important because otherwise you will end up in a big trouble, because this valuation also a key part of the termination valuation. Sometimes the bid value of the replacement contractor is also important. And again, you need to check how reasonable it is, whether the employer has exercised reasonable effort to select a reasonable lowest bidder or something so. And then there is an actual cost, actual accounts of remaining work, and where we have to see whether like employer has given instruction properly, his contract administrator has given proper instruction, or he has administered the contract from his end in the proper manner, but not in an unconscious way, in administering the replacement contract, where he know that he can recover these damages from the earlier contractor, delinquent contractor. So, well, any delays caused by the replacement contractor, like how to deduct these delay damages, but these are again a contentious part of the calculation. And then extra works and variation, as I said, given that there is sufficient correlation between these two. So, well, you need to work on this aspect when you are trying to value your termination clause in accordance with termination claim in accordance with those clauses. So let's look at the owner's basic head of damages when the contractor is in default. Now I've discussed the very basic formula of recovery is that the total cost of completing the project minus the amount of contract with the terminated contractor is the measure of usual recovery. And there are certain things that you need to keep in mind, but there are sometimes the cost of correction is an important part that you need to allow for, because sometimes there can be occasions where the cost of correction is significantly high. I'll give you a good example when, for instance, if the contractor has used the plumbing to do the plumbing system at home, and the work of the house has been completed. Now it discovered at the end the brand of plumbing supplied was of equal quality, but it's not the brand required under the specification. Now there is no point of dismantling and removing, tearing down all the plumbing work and start the work from the beginning, and there is an economic waste. I mean, not that kind of thing, but all other NCRs, non-conformity report, and substandard quality of works, and there is an account of cost of corrective works. And the other thing is extended overheads, which is obviously a part of the owner's claim headings. And it's sometimes there are a number of different ways to calculate based on the rental value and the pre-agreed damages, pre-agreed amount of overheads, but there are also some sort of proofs and substantiation is required. And then owners lost profit, well, because the delay completion because of the termination can be especially damaging to the owner. What you have to remember is there are hurdles in recovering lost profits. First, the owner must prove that the profits were foreseeable and within the contemplation of the parties at the time of signing the contract. The other one is they have to prove with the reasonable certainty that it indeed would have earned a profit, but for these termination and the delay course, he couldn't. And then the other head is the liquidated damages. This is one of the way to work around the problems of uncertainty and unforeseeability that can, the bar or hinder the attempt of owner to recover the delay. So it is allowed sometimes, to come up with the pre-agreed amount of damages instead of going through these difficult sort of calculations. So, but two particular issues are often raised, whenever I talk about these liquidated damages in termination. Well, the thing is, can the owner recover actual damages for the cost of completing the project, at the same time can deduct liquidated damages for the delay use of the work, the completed work, or like they can recover liquidated delay damages until the point of termination, like after terminating the contractor or contractor left the work. Well, it can be both, but you have to look at the terminology and then the way it is drafted or expressly stated in the contract. But in general, the question is yes, as long as you have the contractor has caused the owner damages, they can still recover it. There's no bar, because there should not be a benefit to the contractor who's behind his schedule at the time of termination. And termination itself should not be a benefit to the contractor. And this is sometimes I've seen the occasions where these damages are cut off or limited, or the owner's entitlement is expressly waived. But there is a question: these sort of clauses are still enforceable and valid, and I'm not going to touch into that aspect today. Well, let's move into the opposite side of what we have just discussed, which is a termination for default from the contractor's viewpoint. Now, let's look at provisions from FIDIC that address the termination for the employer's default. But this covers everything what we have been discussing so far. Now, if the contractor is terminated under 16.2 and the termination has taken effect, the employer has promptly returned the performance security and pay the contractor in accordance with subclause 19.6, which I have extracted here. It is basically the amounts payable for any work carried out until the date of termination or up to the point of termination, the cost of plant and material ordered for the work, and the other cost or liability which in the circumstances was reasonably incurred by the contractor in the expectation of completing the work, the cost of removing temporary works and the contractor's equipment, and the repatriation of the contractor staff and labor employed in connection with the works, and pay the contractor plus this loss of profit or loss of other damages sustained by the contractor as a result of termination. So remember what we have discussed under the common law, and this clause is well in line with what we have discussed as a contractor's heads of claims. What is the measure of recovery and how the damages should be calculated is basically contract price minus the cost of completion, or it can be sometimes and plus the profit the contractor would have made on the project but for the termination and his whole expenditure up to the performance. And there is an alternative way to calculate, which means you can get the proportion of the contract price equal to the proportion of the project completed, and then you add the profit contractor would have earned on the balance work. So this is the basic principles of damage calculation, which you might also see like quite in line with what we have discussed just before under clause 19.6 of FIDIC. And then as a code of termination, I mean, notice is also a key aspect, but the notice itself is a separate topic, I understand, but I'm not going to go in that detail, go to that extent of details. But just to give you a brief, one should be very careful as serving an improper notification could, like, jeopardize your entitlement, and they can put you in the innocent party in a danger of wrongful termination. The requirement of this notice is usually depends on the wording of the contract, but one thing is clear: you don't need to spell out in detail like minutely all the details of the contractor's default. or sometimes it is argued that it does not require to state it is issued under the particular clause of the contract unless there is an the contracts expressly required to do so. Uh, but there is no general guideline, but as to what you should include in the notice. But I have given you a general guideline, which I have extracted from Code of Federal Regulation from USA, Section 49 1.0, and you can see they have described what should be included in the notice of termination, the date that the contract is being terminated for convenience or the default, the course of termination to a sufficient degree, and the effective date of termination and extent of termination, and any special instruction for contractors to follow. And the contractor, what are the steps the contractor should take to minimize the impact on the personnel, if it is partially terminated, and what the contractor should do if it is wholly terminated, like what the contractor should do. When these things are the basics that should go in the notice. Like I said, how to serve the notice, whether you need the prior notice or what is usually called in FEDIC as a notice to correct sometimes, so which is a notice prior to notice to termination, and what sort of other notices you require, and what's the procedure, how can just you act after giving the notice. And this is itself is a huge topic. I'm not going to touch that part today. And so far what you have discussed is termination for contractors default and termination for employees default. And there are other causes of termination, which is convenience and frustration. Termination for convenience clauses usually permit a party to contract to terminate for any reason, and regardless of the quality, or regardless of the progress falling behind the schedule. And I mean, there is no reason you should give when you're terminating the other party for convenience, as long as it does not contravene any requirement of good faith and fair dealings, which means that the employer cannot just terminate the other party just for his commercial benefit and just to employ some other contractor, cheaper contractor to carry out the work while keeping half of the money on hold from the previous contractor. Well, these clauses also may represent a code to the parties' respective right and obligation in the event of the owner choose to elect to terminate for convenience. Now, frustration is usually, it's like no one has defaulted on the contract, but the other circumstances have prevented the contractor from being performed as originally intended, or it has become, impossible, illegal, or radically different from what the parties contemplated when they entered into contract. So this is what we call frustration. Now I've extracted clauses from to show the frustration and convenience, and these clauses are extracted from AIA Journal Conditions of Contract, American Institute of Architects, which is widely used in UAE, Journal Conditions of Contract 2017 version. This is I have extracted to show the termination for convenience. You can see the owner may at any time terminate the contract for the owner's convenience and without a cause. The contractor shall cease further operation and take necessary action to protect and preserve the work, and terminate existing subcontracts and purchase orders and enter into no further subcontracts and purchase orders. And the second one in right side is about frustration, which I've extracted from FEDIC 1999, first edition Red Book. clause 19.7, release from performance under the law. And it says parties shall be discharged from further performance without prejudice the right of the other party in respect of any provisions, previous breach of the contract. And if you see, the sum payable by the employer to the contractor under frustration is referred to the clause 19.6, which we have discussed earlier. And let's have a look at the clause. So these claimable heads actually, it's further to what we have discussed earlier. You can see that it's very similar to the convenience. And the same clause is used for both force majeure and termination for convenience, which makes sense because the owner does not allow to terminate the contract for convenience just for pure commercial benefit. The odds are, yes, it can happen so, but the justifiable and the genuine reason is that owner is facing with some financial hardship. So, and that could probably be the reason why it is referred to, why they have referred to the same clause. Basically, you can see there is no loss of profit in this clause. So, yeah, I'm right. Yeah. So then, now what we have done so far is we took the view of the quantum expert or the claims consultant who's acting for the owner's end and the employer, either for owner's end or the employer's end. And now what we're just going to discuss is what's the settlement procedure the contract administrator or the contract administrators should know, or this is the parties contract administrators should know from the attorney's perspective. Well, there are different ways to finalize the valuation or the settlement. One is you negotiate an agreement, or sometimes these are also included as provisions of for side agreements, as side agreements when there is a termination, and then parties have the right to agree on certain headings, and these are included in the side agreements, and then just finalize all the aspects of the termination, and there is no further accounts. And sometimes if that is not the case, you have to stick to the valuation or determination of the engineer or the employer's representative, or I have to wait until the tribunal or a competent court come up with a valuation or on the basis of quantum merit. Or there is an option to like calculate based on the actual accounts and ledgers, especially in the cost reimbursement contracts. Or you can you can select and use the combination of these methods. So this is a settlement procedure, and then while you preparing or defending, or like whether you are an expert witness or a claims consultant, there's one thing which is really critical and important is that record. I can't just stress how critical it is, because the poor record keeping can be, of course, a liability to contractors. And sometimes the damages are reduced to the extent of the not availability of records. So just to maximize the recoveries, the contractors and owners, they should compile estimating and cost accounting data as much as in detail as possible. And yeah, so this is the records are important. And with that, we're going to wind up and conclude the presentation. And thanks all for attending. And now if you have any questions, we can quickly go through them.
Okay, thank you. Uditha, the first question I have for you is, may you briefly consider termination under NEC contracts as well? So if you are familiar with NEC contracts, could you discuss termination under NEC quite briefly?
Well, as I remember, I just don't have the book in my hand right now, but as I remember, the basic headings are almost quite similar to what we have discussed, apart from the procedure where the project manager or like have to have like some sort of have to carry out some sort of steps in the termination and as I remember in the valuation as of date of termination. Well, apart from without having to have a look, I'm really unable to give you a proper advice. Yeah.
All right, thank you. The next question, is material breach the same as repudiation?
Well, it has the same effect of repudiation, I might say so. But repudiation is basically as I explained, like willingness not to perform with the obligation of the contract, or the plain intention to act in a manner which is totally inconsistent with the obligations under the contract. But when you come to serious breach, I mean, where it differs basically, for example, the serious breach depends on the gravity of the obligation. For example, in non-payment, if the owner does not pay the contractor for the work performed, let's say out of 200 million, there is a last payment of 15 million balance. But this can cause a serious breach of the contract because the payment term is basically by necessary implication, it goes to the heart of the contract. And this is the very reason why the contractor entered into contract with the employer. So that can constitute a serious breach. So that's basically the difference, because like the breach of the innominate terms is a serious breach of the contract. And repudiation is basically the incapacity or willingness to perform in totally inconsistent with the contractual obligation those sort of things. But if you look at the termination clause of the major contracts, these are basically combination of these two, the repudiation and serious breach of innominate term. Yeah.
Okay, thank you. The next question is, in the case of continuous delays in payments by one party, can the other party consider the contract being repudiated?
Continuous delays, yes, they can, but you need to carefully look at the fact of the case specifically. For example, I would say if there is a withholding notice, or if there is a provision to withhold the payments in the case of substandard work, so this may come in the form of argument. But it does not necessarily say that you have to cease the contractor's payment as a whole. You have to still pay for the work completed, and there is necessary provision to withhold some money for the substandard work and as a cost of correction. And these are a procedure. But the way you have explained, yes, it sounds to me it can cause repudiation. So because it's a continuous non-payment of the contractor's money. But you have to be very careful when you follow this matter in the courts sometimes, because like if there is, for example, because you have to differentiate between non-payment and the delayed payment, because sometimes it can be a like non-payment of the last payment and like the delay payments of the previous cases, like a combination. So yes. On the face of it, yes, it can cause a repudiation. Yes, would say so.
Okay, thank you. The next question, I'm not sure I understand it. Hopefully you will. Can the owner terminate a contractor for not performing in the available front, even when the minimum front as per contracted as per contract is not handed over by the client.
Sorry, hit me again with the question.
Can the owner terminate a contractor for not performing in the available front, even when the minimum front as per contract is not handed over by the client?
Not handed over by the client. Minimum front is not handed over by the client means I should assume that there is no site possession, and the section given to the contractor is not performing with the same. It can cause a repudiation, but you have to be very cautious and like about the fact that whether the contractor really has the ability to perform in the given front, because it can be his resources allocation that is hindering him to perform in the given front. But it's subjective. For example, if I'll take an example to explain it. For example, let's suppose the contractor is given a part of the site where you have the shoring works to perform with the work. Contractor is given the portion where they have pile caps and all these enabling works to carry out, and where the employee is waiting to shoring approval from the authorities to proceed with the shoring works. So now the contractor is not proceeding with the piling works. Could be that the contractor has earlier planned to perform the shoring works at the beginning, and where he's like planning his pre-qualification and to get on board the piling subcontractor in 2 or 3 months. And now where they have been given the piling front first, and they have a trouble, allocating the resources readily to carry out the piling work. So this could not constitute repudiation in that case. So it depends on the facts of the case. But if the contractor is is delinquently or plainly saying that, oh no, I'm not proceeding with the work, or I'll put it in another way, stubbornly saying that I'm not proceeding with the work in the given front without a reason, this could, of course, constitute a repudiation.
Okay, thank you. All right, jumping straight to the next question. Thank you for your detailed presentation. You have indicated termination under common law. How about termination under civil law, maybe with a combination of Sharia law where such jurisdiction exists? And how does one administer termination?
Well, that's a good question, because the civil law is a codified law, basically. So the civil codes usually prescribe what is the occasion of termination. But in most of the cases, these occasions we've seen are being used during the COVID time, where most of the civil code permit the parties to terminate for the frustration and the impracticability, inability to perform the work. But apart from that, there is an also aspect where you have to keep in mind that it reserves judges the decision or to say or to final say to come up with whether the termination is reasonable in this occasion or not. So sometimes the judge can rule whether the termination is valid or not. So it's not so easy as it seems under codified law. But the principle wise, it is common to which the principles are quite common to common law. But the way how these the rights are being exercised is quite different. The principle wise, basic principles of termination, default, frustration, and the impracticability, legality, those things are quite the same. But the way these rights are enforced, the way these rights should be exercised are different. But there are some court cases, of course, recently where the termination is permitted, for convenience and basically using the parties' express right under contract. Because what you have to keep in mind is that the codified law doesn't usually intervene, similar to common law, doesn't usually intervene the wording of the contract. where the parties have agreed, in this case, I'm going to terminate the contract. In this case, I'm going to terminate the contract. Well, it seems reasonable in this case to terminate, I will terminate. So the court will also recognize it. The exception is the termination for convenience, whether sometimes it's questionable whether it is allowed in some jurisdictions.
Okay, thank you. All right, next question. Termination due to default of the contractor and frustration are two different legal terms. Please throw your idea on this.
Yes, of course. Default and the frustration are two different things. The default in the sense like the contractor is not performing with the work. The contractor, after giving his notice to correct the defective work, is not rectifying the work, and the contractor is in a bankrupt situation, or it goes into like liquidation sometimes. So these are, of course, the defaults. But as a where in the frustration, there should be a clear impracticability or like inability or the impossibility to perform with the work temporarily or permanently. Bear in mind that sometimes like for instance in USA there is this concept of temporarily impossibility or temporarily impracticability, so which is also sometimes argued under frustration. And this is the basic difference actually. There is an like impossibility, the supervening illegality, and plus the default where the contractor has acted in such a way which is inconsistent, which is contrary to what is in the contract. So he's defaulting his promise, something like that. Or it can be like schedule wise, quality wise. Yeah.
Okay, all right, thank you. I will just say before I ask you the next question, I will point out that I am aware of your time. We do have 16 more questions, so when you need to tap out, just say good night and take a bow. But if you are able to continue answering questions, that would be wonderful.
Well, of course, I can allow my time for a few more questions. Why not?
Okay. All right, then. Thank you. Okay, next question. What if the payment for correction, what if the payment for correction is significantly high? How does one resolve this issue? Where does and at what stage of the performance guarantee or the bond kick in?
Well, well, you have to wait. It's a good question. I mean, you have an options where you have come up with the valuations, or that valuation is recognized under, for instance, let's say the FDIC clauses under dispute resolution clause. So when you have an adjudication award in the UK, for instance, when you have arbitral award confirming yes, this is the case, so, or you have in this case, so yes, it's a good opportunity that you can liquidate the defaulting contractors' bonds. Or sometimes if the contract prescribed, which is I believe in the FDIC case contract, so you have the right to liquidate when you have the valuation at hand. Let's say, for example, let's not go into in complex cases. Let's say the contractor is performing defectively and you give the notice and he's not complying with this rectification works, and you have the right to appoint third party and get the rectification done. In this case, you're not necessarily required to wait until all the things are completed and go into dispute, and you have the final say from the adjudication panel or the arbitral tribunal. You don't have to wait. So you can immediately recover these monies. Apart from that, as I explained during the presentation, sometimes you have to be very careful if you are an expert witness, if when you're coming up with the cost of correction, because sometimes it's not your say, it is the say of the tribunal or the competent court to direct you to, to do this exercise. Because as I said earlier, like if the whole plumbing system needs to be teared down, and removed from the uh, house. I mean, you cannot really assume so, because it's an economic waste to begin with. The other thing is, someone has the authority should direct you to come up with come up with a solution for this thing. I mean, owner can still use this system and take the benefit of it. In that case, you might not need any allocation for cost of correction at all. But sometimes these cost of corrections can be deducted, of course, if the given concrete grade is not used and you have to now demolish the part of roof slab, for let's say. Yes, these things are still can be considered. So it's again a complex area, and sometimes it is, of course, not so complex as well when you're talking about some minor rectification, non-conformity reports. For example, let's say when the contractor left the site, he has not cleared the debris, or he has not cleared the debris for last 2 months. So these have to be removed now with the replacement contractor. Yeah, I hope this answer your question. Yeah.
There was a final bit of that. What if the performance guarantee is insufficient to cover the correction?
Well, if the performance guarantee is insufficient to cover the things, and then you have an opportunity to request it as a claim, but I'm afraid you can only get these things recovered if there is an arbitral award or judgment from the court, because you can't just go and recover something from his assets, you know. But let's say you have calculated everything, you've liquidated the bonds. Oh, I have another 100 millions to be recovered from the contractor. But where you recover these things, you have to go for the contractual procedure and start the dispute resolution, and to have an award from the contractor to direct these payments, or bear the losses.
Okay, thank you. No, sorry about that. The next question is, how are exclusion clauses dealt with, such as no additional payment if the contract is extended, or the contract cannot suspend, or the contractor cannot suspend or terminate the contract?
Well, the one that you have explained at last, I doubt those things are enforceable, because one thing I've under common law, it should not seen as as a windfall to the owner. He can just take a benefit of his own default, and plus it can't be a penalty. And then the other aspect, so the other thing is, what you have to remember, they can't limit the liability in case of his own negligence or misrepresentation, or negligent act. The liability clauses are, of course, enforceable, but it has to be drafted in a proper, in a specific manner. Otherwise, those things are not enforceable. But what are the clauses you have explained at first and second?
No additional payment if the contract is extended, or the contractor cannot suspend or terminate.
The first one could be enforceable, but again, it has to be tested, because as I said, there are ample opportunities for the owners to use it against the contractor. As long as it says this has to be exercised in good faith, so it can still be enforceable. But so those are the basic rule. It has to be properly specified and has no, the features of a penalty or, like unjust enrichment, and yeah, and can exercise in bad faith.
Okay, and the next part of that question goes back to the last question you answered. What is the maximum amount an employer can recover if he terminates the contractor for the contractor's default, whether it is equal to the performance bond or more?
More. As long as the employer can calculate the actual damages, the limitation of the contract price or the bonds are not necessarily a bar to recover these damages. The performance bonds and all those bonds are just an indicative value of the agreed damages. But assume so, for example, like the contractor is building a fruit processing plant, which is, of course, like the employee's profits are depends on the seasons. And because of the delay and termination, there is a huge loss to the employer. I mean, this can still exceed all the bonds and the contract value, but still can be recoverable as long as there are the proof to that account.
Okay, and the final part of that question, can liquidated damages be proportionate based on the ratio of completed and remaining works?
Liquidated damages to be proportion for the ratio of remaining works, the ratio of completed works. Well, I don't see any valid reason to do so, because if you are delayed, which means you are delayed, for instance, if you are delayed due to termination by 15 days, you're still losing a 15 days revenue when you are ready and completed with the works to to gain your revenue. So you are 15 days behind, the works are completed 15, unless of course the replacement contractor accelerated and recover these delays, and then you are 15 days behind. And of course, yeah, you should have the right to recover for all these 15 days. So but this may sounds a valid argument, of course, when you are calculating a work based on the proportion of completed work. And for example, the contractor has worked only a portion of the whole of the works, and that portion has been gone off, and the balance portion is still continuing. So something of sort, yes, allocation can be done, the proportion can be done, but I don't see any reason why you proportionate the liquidated damages for completed and non-completed part.
All right, thank you very much. How are you for time? Are you still okay?
Yeah.
Okay, all right. The next question. The contractor's progress has been slow, creating doubts about the completion of the work as initially planned. According to the express terms of the contract, the employer is entitled to terminate the contract under these circumstances, and they intend to do so. It is well known that in such a scenario, the employer can recover their costs. However, they may also impose a penalty. They also impose a penalty in addition to recovering costs?
Only if you have the express right to impose a penalty, and that right is recognized by the prevailing law of the jurisdiction. Yes, but well, if you don't have, you have to. I'm afraid you have to resort to the recoverable heads given under the contract, or the actual damages. Yeah, but what penalty you're talking about? I presume this is a penalty as an unconscionable amount you're just deducting from him because of his default, apart from the actual damages. And if I presume so, yeah, it depends on, like, your wording of the contract and the jurisdiction and enforceability in the jurisdictions. If it is there in the contract and as an additional penalty, for example, like, there are some reasons why they put so, because sometimes you can calculate the actual damages and you can put a pre-agreed amount of damages, but there are some things you can't really calculate, isn't it? Like for goodwill and loss of business and some, some sort of the other party's heads, like, winding up cost, the interest, sorry, the winding up cost, for example, like because of the termination that you are closing out the early hire agreements, you have to pay charges and penalties, but these things are of course calculated. It's can be calculated, but there are things that you can't calculate. If you want to allow for these things, of course this can be, yeah, you can be put it in the contract. So yeah, just one more questions and then we'll wind up.
All right, well, thank you very much. Then the last question, if the contractor is anticipated to be in loss at the time of termination, would the payments due to the contractor be reduced?
Yeah, for sure. I was wondering whether I didn't like explain this in like, yeah, of course, because like the contractor's loss should be I mean, one second. It should be projected further. I mean, if the contractor is like losing money on the job, I mean, there is no point, like contractor should be awarded like future profit, like for like in this I remember I explained this slide, like if like the contractor is losing money on the job, like I mean, this has to be reflected in the calculations. But how to calculate is like there are formulas in some countries, like to calculate the actual expenditure by the contractor up to the termination, and then minus progress payments and the minus unused value of materials and minus the contractor's projected loss in the case of termination for default. Yeah, this is a good aspect, but again, you need to be very careful, because when deciding whether contractor has made the loss and you are trying as an expert witness to allocate for, further procedures, you still ended up in trouble. So this has to be with the authority of the tribunal or the court, but there has to be a proper calculation to allocate the losses. But sometimes, of course, like the opposite sides of the same story, the contractors may find more profitable jobs. Let's say the employer has terminated them, and they can go and find more profitable jobs. And although it is very difficult to prove in that case, like for the employer, that the contractor is gaining money because he would have had it anyway, would have had it and gone and earned the profit anyway. So yeah, like it should still be accounted. Yeah.
Okay, all right. Well, thank you very much. And thank you for staying this long. And thank you also for offering to provide further answers to everyone that we ran out of time for. I appreciate this so much. This has been a very helpful webinar. And thank you to everyone who has stuck with us all the way to the end. Yeah. And if you requested additional information, you will get the link to the website that has the replay links. And also, I will include information. We were supposed to have a webinar in July, but that was a miscommunication between myself and the presenter. And actually, it will be in just a couple of weeks' time on the 21st. So that will be on common pitfalls arising from careless construction services procurement. All right, so I will have the registration details for that. And of course, that will also be on LinkedIn and going out to our newsletter subscribers. Well, Uditha, thank you so much for everything today.
Okay, thanks.
All right, and I think with that, we will say goodbye. So goodbye, everyone. Thank you very much.
Thank you.